One of the biggest ways of cleaning up the swamp is this little provision that people might not be aware of. It's called quo warranto. It is the power actually vested in attorneys generals across the country. Basically, what it is if state attorney generals, if somebody comes up and says, you get a bunch of people together and you go over to your state attorney general and you say, hey, state attorney general, this particular person is not supposed to hold public office. They're not supposed to hold that office because they're in violation of the Constitution. You know, they weren't born here. They were born outside of the country, all these different things. It's just a fascinating way, because then it's not just totally trusting every single person who runs for public office that they are in total compliance with the Constitution. It allows a check for us to check a member of Congress, a member of the Senate, President of the United States, any person who is holding office even in your state, to under quo warranto, to be able to say that that person constitutionally, either your state constitution or the United States Constitution, cannot hold that office. The consequences of doing this is that if the person that you challenge to their constitutionality of holding public office, if you fail, the person who holds that office gets to collect damages. Now, there are rules to this in all the 50 states. So let me just try to be a little bit more kind of like apolitical about this, because as I've said, if you're going to clean up the swamp and you're going to restore honor, a core provision is that honor should be above party, that honor and ethic must be the central principle upon which both parties adhere to, and it creates a more ethical society, so that we can live up to the standard where Benjamin Franklin literally said that if you don't have ethical people, you cannot have freedom. Washington, where ethics is so important, it's just like water. So solving the swamp and addressing ethics are like that. So let's just take one of the provisions. Like, let's take, not Trump, but let's look at, say, the Obama birther claim, which was total bullshit. I'm just going to say it as an example, right? The whole birther situation could have been resolved in literally a month, maybe two, right? Because, people could have presented their evidence, say, to the Texas state attorney general. And this Texas state attorney general looks at your evidence and says, yeah. Obama was not born in the United States. He's not an American citizen. Yes, that's true. And then what he would have to do is run all the way to the U.S. Supreme Court, and he'd be able to do this, to be able to claim under quo warranto that Obama was born outside of the United States. Now, he would have to prove that to the U.S. Supreme Court. And if the U.S. Supreme Court determined that no, Obama was born in Hawaii, Obama would get money, some level of judgment. He would be able to countersue the people who sued him. You know, it's a small thing. It's like $5,000 is what the penalty is. Now, I'm just going to give you what comes out of my state, the state of California, which is the quo warranto requirement in my state. But this is the same state, the same qualifications basically in all 50 states. Of course, this quo warranto, they're talking about the state within the state. But only state attorney generals can challenge federal officials like congressmen and senators and, of course, the president of the United States and probably other office holders. But you have to be 100% right. And it can't just be you doing it. You have to be doing it with an attorney who is willing to put his own stuff on the line for claiming that this is unconstitutional. So let's just hear what my state attorney general says here in the state of California.
Quo warranto, right to public office. What is quo warranto? Quo warranto is a special form of legal action used to resolve a dispute over whether a specific person has the legal right to hold the public office that he or she occupies. Quo warranto is used to test a person's legal right to hold an office, not to evaluate the person's performance in the office. For example, a quo warranto action may be brought to determine whether a public official satisfies a requirement that he or she resides in the district, or whether a public official is serving in two incompatible offices. Quo warranto is not available to decide whether an official has committed misconduct in office. A person who commits misconduct in a public office may be penalized or even removed from office, but quo warranto is not the proper forum for those cases. Other processes are available for that purpose. The term quo warranto, pronounced both quo warranto and quo warranto, is Latin for by what authority, as in, by what authority does this person hold this office? The term quo warranto is still used today, even though the phrase no longer appears in the statutes. Quo warranto originated in English common law as a process initiated by the Crown to find out whether a person was legitimately exercising a privilege or office granted by the Crown, or whether the person was instead intruding into a royal prerogative. Early California law abolished the writ and substituted a statutory action, identical in purpose and effect to the common law writ. Current California law provides that the action may be brought either by the Attorney General or by a private party acting with the consent and under the direction of the Attorney General. The statutes relating to quo warranto are in the California Code of Civil Procedure, starting at Section 803. How does a quo warranto action get filed? A quo warranto action may not be filed without the approval of the Attorney General, except in those cases where a public agency is authorized to file for itself. The remedy of quo warranto is vested in the people, and not in any private individual or group, because the question of who has the right to hold a public office is a matter of public concern, not a private dispute. The requirement of obtaining approval also serves the important purpose of protecting public officers from frivolous challenges. In order to obtain the Attorney General's approval, a private person or a local agency must file an application pursuant to the rules and regulations issued by the Attorney General. Cal.Code Regs. Tit. 11, Sections 1 through 11. The application and supporting documents must be prepared by a licensed attorney. Important, quo warranto applications must be submitted in electronic, PDF, format. Please email your application, or any questions about submitting an application, to Senior Assistant Attorney General Mark J. Nolan at mark.nolan@doj.ca.gov. The party who files the application with the Attorney General is called the relator. The responding party is called the proposed defendant or the defendant. An application must include a verified complaint, a verified statement of facts, a memorandum of points and authorities, and a notice to the proposed defendant giving him or her at least 15 days to show cause to the Attorney General why the application should not be granted. The application must be properly served on the proposed defendant, and filed within 5 days of service with the Attorney General. The proposed defendant is given 15 to 20 days to respond, depending upon where service is made. The relator may then file a reply within 10 days. The Attorney General may prescribe a shorter period of time in special cases or upon a showing of good cause. These response times may also be extended by stipulations filed with the Attorney General, or upon a showing of good cause. After all of the papers are filed, the Attorney General's office evaluates the facts and the law in order to determine whether to grant leave to sue. Because this approval process is an administrative function, not a judicial one, there is no opportunity for formal discovery proceedings between the parties at this stage. From time to time, the Attorney General may ask one party or another for additional information in order to make a full evaluation of the application and responses. After sufficient time to evaluate the matter, the Attorney General will render a decision either to grant leave to sue, or not to grant leave to sue. The decision whether or not to grant leave to sue involves an exercise of discretion, and will rarely if ever be disturbed by a court. How does a quo warranto action work? If leave to sue is granted, then the relator may file a quo warranto action in the appropriate superior court. From that point on, the matter is a judicial proceeding, subject to the procedures and rules of the court. However, the relator must proceed under the direction and supervision of the Attorney General throughout the action. Before filing a complaint in the Superior Court, the relator must make any changes or amendments that the Attorney General directs. At any stage of the proceeding, the Attorney General may withdraw, discontinue or dismiss the case, or any part of it. Additionally, the Attorney General may assume management of the litigation at any stage. In the quo warranto action, the Superior Court will decide whether the defendant is lawfully entitled to the office in question. If the defendant is not entitled to hold the office, the court may decide who does have that right. If the court decides that the defendant unlawfully usurped the office, the court will exclude the defendant from the office and assess costs. The court may also, at its discretion, impose a fine on the defendant of up to $5,000. If the rightful holder of the office has suffered damages, those may be recovered in a separate action. A relator may not file an appeal from the Superior Court's decision without the approval of the Attorney General.
I really hope that you find that stuff informational. And if you do, and you think that my work is something you would like to support, please like, subscribe, and share and comment on this video. We really need to have these big discussions about the issues of restoring ethics and honor to Washington, D.C. That's why I made the little book, which is really, it's not like a legendary writing. It's just my concepts of the basic laws that we need and the constitutional challenges that we need, that would create legal, constitutional, enforceable standards in Washington, D.C. for basic ethic requirements, which right now we are completely absent of. But we can get there if we work together and realize that ethics and honor are things above party. So long as we do that, we can end the swamp together, because everyone wants the swamp gone. And we can do so as Americans upholding the values of the Constitution and not a bunch of bickering children. So please, again, like, share, and subscribe and comment. Thank you.